No one was hurt in the blaze this morning. However, the fire is estimated to have caused approximately $25,000 damage. The fire was blazing vigorously when two pumpers and a ladder and the chief's car was called to the scene. Firemen had to attack the blaze from the roof in order to bring it under control. According to the fire report, the blaze started at the fireplace and traveled up the inside of the wall. Most of the damage was confined to the attic. However, some portions of the house did sustain smoke damage. Firemen say fires emanating from the fireplace are common this time of year, and they urge all persons who are using fireplaces and other types of wood-burning stoves to use extreme caution. Janet May, WSFA TV News.
I'm not sure. What can they do? You know, everywhere we turn, the door's closed on us, so I don't know.
I don't know. I think it's kind of in a difficult situation in that it's hard to force them to be more efficient. You say, well, we won't give it to you, and they say, well, we got to lay people off. I'm sure in that management system somewhere there's some room for improved efficiency. And like anything, it's, you know, you got your organization that cut. It's interesting to find out what percentage of the people laid off were upper management versus the average hourly worker. That would be interesting to find out.
Do you think that the layoff proposition is necessary?
I don't know. I think it's kind of playing games with, you know, sort of like they say, well, we won't give you a rate increase, and they say, well, I'm going to lay somebody off. I think they could have laid off maybe a third of the people that were laid off.
The way prices are rising, they have to make the cut somewhere, and whenever government intervenes, it's gonna, to me, it's gonna cause trouble. Even though I think you do have to put a limit on what they charge, but yet, the way costs are going, the rates are gonna have to rise with the rest of the costs too.
With numerous court actions pending, it appears that the Alabama Power story will be in the news for many months to come, with no apparent solution in sight. This is Norman Lumpkin, WSFA TV News reporting.
Have been perfected from the Alabama Public Service Commission order that's underlying the case by the other parties in that proceeding. So all matters of appeal are now before this court. Both the company and the commission have appealed Judge Phelps's order under Rule 4. And now the company seeks to stay or supersede that order, and that is what is before you this morning. It was found to have had its property confiscated without that commission order. It now cannot collect anything under that order as a result of Judge Phelps' injunction. Ordinarily, the utility is appealing and seeking to have the commission's order declared to be confiscatory. Here we have a commission order which itself has found that the company is suffering confiscation. And the remedial order that was granted by the commission to prevent that confiscation is what we're now being prevented by Judge Phelps' injunction from undertaking to collect.
Here, the judge has found, in effect, that the order is void because certain procedural requirements were not attended to, as I understand.
Right.
Whereas in the other cases, there's never an attack on the procedure. It's simply a question of what is the proper rate increase. Now, that's a difference. Is that a difference without any real meaning?
We would say that it's without real meaning because of the fact that all that is already before you in the appeal cases.
All right.
It was put there, and I get to this as a matter of jurisdiction and maybe anticipating a little the argument about supersedious, that all jurisdiction has been removed to your court by the operation of that appeal. That's the L&N case, the Tom Walker case. It had already been removed before the proceedings before Judge Phelps. But it is now before you on the appeals of the very parties who raised it before Judge Phelps, and they can raise it here and should raise it
The
here.
reason I asked you that question was you're up here asking us to stay
Yes.
and to grant a supersedious bond. Now, the difference in the entitlement to the stay in this case, the stay under the formal proceeding is what really concerns me because of the nature of the way the case comes up.
That's true, but the result is the same, Your Honor, in that the company is denied the right to recover the rates to which it's been proven to be entitled. So we say it really is that there is a distinction, but the main distinction is the fact that that the company has already been found to have been confiscated. I don't intend to belabor that here except to say that the difference in a 4% return on equity and a 12% return on equity is not just a matter of confiscation. That is grievous confiscation, and the effects that that is having on Alabama Power Company cannot be too strongly emphasized to you. This is irreparable injury, if there ever was irreparable injury.
In the first place, he told you that appeals had been perfected from these perfunctory orders of the Alabama Public Service Commission of November 22nd, 1978 by all the parties. But he failed to tell you that contemporaneously with those appeals, and specifically as a part thereof, each of those parties moved this court to dismiss those appeals, specifically on the grounds that the commission did not have the jurisdiction, power, or authority to issue those orders, that they were void. Secondly, that the Supreme Court that an appeal would not lie from a void order. And thirdly, that the orders were void on their face for multiple reasons. Those motions were included in the notices of appeal and were filed contemporaneously with this court. Now, he also failed to tell you of another development that has occurred.
So you are not attempting to appeal the increased orders if they are finally upheld as being valid. You are not appealing those orders of November 22.
No, sir. If this court, we filed a motion we filed a notice of appeal and a motion to dismiss the appeal, which brings to this court conceptually the jurisdictional issue.
You are not appealing those increased orders.
They are. If it's a void order, we can't appeal it. If it is not a void order, that appeal would lie. It's up to this court. And that's the only way I know to raise that issue firmly with this court and to maintain the position that we have taken throughout that those orders are void.
But if not void, you are insisting on appeal. That's your question that
Yes, sir.
Justice
Yes, sir.
Sachs has
Yes,
addressed.
sir. If not void, but we take the firm position before this court that it is void. Yes, sir.
You are contending, if not void, that
That
they are unreasonable?
Absolutely. Yes, sir. Now,
and then kindles the lights. And this is the story of Hanukkah.
The celebration of Hanukkah predates the birth of Christ by almost 200 years. Even though it is a holiday celebrated by those of the Jewish faith, its message of religious freedom transcends the boundaries that often divide the world's religions. Dennis Latham, WSFA TV News.
We're here to ask the governor, as his last official act in office, to commute the sentences of all the people that are currently incarcerated on death row here in Alabama.
How are you doing this?
We've done it by a petition signed by all of us that's going to be given to the governor that makes that particular request.
Is this the first time this has been done?
No, we did this, first began it 3 years ago, and it involves more than the act of asking the governor to pardon or not pardon, but commute the sentences of people on death row. We hope that these kinds of demonstrations will cause all of the people of Alabama to think about the death penalty and to think about why we have it and whether or not we should have it. And that's primarily why we're here.
What sort of people make up your group?
All kinds of different people. They're Catholics, Protestants, Jews, professional people, laborers. It's, I think, a cross-section of the kind of people that live in this state.
Thomas Reed versus State of Alabama on the relation of John Alley James.
Today's hearing by the state Supreme Court dealt with a ruling by Circuit Judge Joseph Phelps that removed Thomas Reed from his seat in the legislature because of his bribery conviction last year. Today, the justices issued a stay of that order, which in effect means that Reed will be able to serve in the legislature while an appeal is heard on his bribery conviction. As soon as Reed posts a $10,000 bond, he may resume his post as representative of Macon and part of Bullock County. The justices first asked the attorneys for both sides if they didn't want more time to submit briefs on this question. They adjourned, waiting to be notified by each attorney of his decision. But in conference, the justices changed their minds and decided the issue in Reed's favor. They gave no opinion on this question, but in hearing the arguments, one justice said that Reed deserved his day in court, that if Reed ultimately was found innocent of the bribery charge, then he would have been denied unfairly the privilege of serving in the legislature. But Reed still faces the final decision on his 1977 bribery conviction. The State Court of Criminal Appeals recently upheld a lower court conviction. It now must be decided by the Supreme Court. At the same time, if the Supreme Court upholds the lower court convictions, the justices must decide if that makes Reed ineligible to serve in the state legislature. Glenda Webb, WSFA TV News.
Dr. Wayne Teague says his Department of Education has run smoothly, harmoniously, and in most respects has made it through the year very well. Teague says there is the possibility of proration in the department's $1.18 billion budget for the year, but education-wise, things are looking good.
But the SAT scores, which have been going down throughout the nation for the last decade, continue to go up in the state of Alabama. Our seniors who take the SAT continue, as have the past 3 years, to be above the national norms. Also in the area of basic skill instruction, in all areas of basic skill at the grades 4 and 8, continue to rise each year. So we think the low score syndrome has ended in the state of Alabama and will continue to be on the upswing. Much has been said this year about minimum competency testing. We're well on the way to developing what we think will be the best program in the nation. 7 counties and city systems now in a pilot year of this program.
Teague says a very concise bill will be introduced to the state legislature this coming year, which will include at least a $1,000 per teacher raise, in addition to an increase of 3 workdays for in-service education. On the subject of competency testing, Teague says a good plan is underway for the testing of pupils. As for the testing of teachers,
I would strongly suspect that if it's left to me, I will wait until our minimum competency program of students is well documented and see what it tells us before coming forward with the competency test for teachers and other educators.
Teague emphasized that the board has adopted new certification requirements, which he says will eliminate fear of incompetent teachers in the future. Despite all of the improvements within the entire system, Teague does concede that there are areas that need a lot of improvement, areas such as the social sciences, basic education, and economics, and Teague says a great deal of emphasis must still be placed on the state's entire vocational educational system. Within the department, Teague says his reorganizational efforts will still be aimed heavily at the department's regulatory powers. At the State Department of Education, Chris Grimshaw, WSFA TV News.
Mac Phillips claims that enough votes were tampered with during the Democratic primary to cause him a place in the runoff election. Circumstantial evidence gathered by Mac Phillips shows possible vote tampering in 9 counties. Although this investigation comes approximately 3.5 months after the primary, Mac Phillips says the smoke has long since disappeared.
You know, with all due respect to Attorney General Baxley, I'm glad that he's finally establishing a committee to look into the charges, but it's been 3.5 months now since the end of the first primary. And if there were smoking guns in existence at that time, the smoke has long since left the scene and the guns have been buried. So as far as finding direct evidence, it's going to be harder now, more than ever before.
Attorney General Bill Baxley says the investigating committee will hopefully wrap up their study of the matter before he leaves office on January 15th. He says if traces of election fraud are found, the next step will be to take the case to the grand jury.
The 3 members are Assistant Attorney General John Young, Assistant Attorney General Sally Greenhall, and Assistant Attorney General Rick Middleton. And they're going to be in touch with Mr. McPhillips and invite him to come up here and present any evidence he has of any wrongdoing, and if he has any evidence, we'll try to wrap something up in the next 3 weeks before I leave office.
Is it possible that there will be another Attorney General's election?
No. Now, the only thing that the Attorney General's office can investigate is the criminal aspect of it, to find out if there was some election fraud, and if there were, then we'd go in and try to get indictments and send the people to prison for it. As far as a new election, now that would have to come by McPhillips filing a suit of his own to set it aside, or somebody interested in his campaign. And the Attorney General's office wouldn't have anything to do with that. We're just going to check into what he, is charging about people violating the law, and if we can find out where they did, we're going to try to get warrants for them or indictments or whatever and prosecute them for it.
This investigation probably won't give the people of Alabama a new Attorney General's election. However, it should clear up doubts as to whether there was election fraud during the 1978 primary. Janet May, WSFA TV News.
Chris, Mobile Book Mart, which owns Jimmy's Newsstand, and Continental News, which I understand from John Bell owns Forum Books. Both those corporations were prosecuted by this office, the District Attorney's Office, and the prosecutions resulted in a conviction and a $30,000 fine being imposed on Forum Books for selling obscene literature, and a $20,000 fine on Jimmy's News Agency against the corporations Mobile Book Mart and Continental News. These judgments were not paid. They filed notice of appeal from the criminal cases. No bond was made in regard to the judgment. That is, when a case is appealed and there's a fine involved, they need to post bond on the amount of the fine, so the fine will be covered in the event they lose the appeal. This was not done. So we executed this morning And Forum Books, as I understand it, filed notice with the clerk this morning that they were posting an appeal bond on their $30,000 fine. The status of Jimmy's Newsstand is uncertain at this time. I understand that there's some arrangements being made for the posting of the bond or the payment of the fines. So that's what we're about this morning.
Is that a train?
This is just merely one man's opinion and outlook from one group, and I really personally do not believe that the price of hamburgers are going to reach what Mr. Ling has predicted. The United States Department of Agriculture has estimated that overall beef prices in the United States this next year, 1979, would be about 10 to 14% more than they were in 1978, and perhaps hamburger meat would probably go up to about 20%. It went up at 45% in 1978, so it will probably go up about another 20% in 1979. I might want to add, too, that the fact is that there is no real shortage of beef in this country. The fact is that we just have less cattle now than we have had in the last few years. The beef demand is up extremely high, and the supply of beef is down. There is no shortage. There's no reason to panic. But we will have less beef next year, and we will have some higher prices in beef next year than we've had.
To some farmers, Act 135, which was passed in this building, will be a small blessing. Act 135 virtually reorganizes the way farmers can assess tax on their farmland. The act, part of the LID bill passed in a special session earlier this year, allows farmers to have their farmland appraised on its current use as opposed to its market value, which could be substantially higher. However, there are apparently very few farmers who are aware of the opportunity, and the deadline is quickly approaching.
I just talked with the Montgomery County tax assessor, Mr. Marvin Driver, and he says if the letter is postmarked by January the 1st, he will still accept the letter of intent, what the property will be used for. Now, what they should include in the letter is the use of the property, which the use of it as of October the 1st, 1978. They ought to have a description of the property and the uniform parcel number and the number of acres that's devoted to each of the following uses: row crops, pasture, and timber.
Now, what they qualify for is the sketchy part. Nobody connected with the county tax assessor's office or the Department of Revenue will allow themselves to comment on that act. Why? Well, there seems to be a question of interpretation of the act. and those in the buildings behind us won't even say exactly what parts. And the head of the Revenue Department, Carol Stow, who's out of town, has requested the Attorney General's office to issue an opinion on the exact interpretation of this act. When and if an opinion is issued isn't known. The confusion over the exact interpretation of this lid bill was predicted during the hectic special session which saw it passed, many of the legislators saying that this lid bill could provide us with many more headaches than solutions. At the state capitol, Chris Grimshaw, WSFA TV News.
Many people do not realize the volume of commercial and private traffic on the rivers near Montgomery. Barges such as this one are regular sights on the Alabama River, and with the completion of the Coosa and Tallapoosa River systems in the 1980s, there will be even more traffic. Pat Dixon, who operates a marina on the Alabama River, says they have been aware of more and more commercial and private traffic over the past few years.
We've seen an increase in launchings from around 80 boats a month in our best months to around 300, 350, and we think that'll go up to around 400 to 500 next summer. Commercial traffic, by that I mean barge traffic, we have right behind us over here a real active port. It's a chemical fertilizer operation, and they bring probably 4 or 5 barges up here every month and a half, 2 months. The gravel industry located north of Montgomery is continually hauling gravel, 3-4 barges a day. This, of course, was non-existent 5 years ago, so you can't put a percentage on an increase when it's brand new business.
What effect will the development of the Coosa and Tallapoosa riverways and other development along the river have on the traffic?
Well, as the river has developed more, we'll see the same thing that we've seen. We started selling gas here. It took us 3 years to sell 4,000 gallons. Now we sell 4,000 a month, approximately, and that's because there have been no facilities, so there was no traffic. There are facilities being built at Hurtsboro, all up and down the river. A great recreation park is being built out near Maxwell Field for the public, and we think it's going to be as busy as Lake Martin during the summertime.
Are there any drawbacks to a large increase in river traffic? Are there going to be some things that are going to have to be done to ensure, say, the stability of the river?
I don't think so. This river is raised to a minimum 9-foot channel, but it's staying in very old banks. We're not talking about running over into new areas, and we're not talking about banks that slough. The barge traffic is kind of interesting. They create less of a real wake problem than speedboats do, so we're glad to see them.
Development along the Alabama River near Montgomery in both the commercial and the private sector continues to grow at a steady pace, and that's making a lot of folks happy. Dennis Latham, WSFA TV News on the Alabama River. Today, the last day of 1978, is a Sunday, and according to state law, no alcoholic beverages can be sold. There are about 9,000 licenses issued by the State Alcoholic Beverage Control Board in Alabama for the sale of the controlled substances. All but a few of these licenses will be inactive today. Greeley Wells, a district supervisor in the license division of the State ABC Board, says today, even though it is New Year's Eve, will be treated like any other Sunday.
The law specifically prohibits the sale or serving or giving away or drinking alcoholic beverages in any cafe, lunchroom, hotel dining room, or any other public place on Sunday. And we are obligated to enforce the law, and that's what we will do.
In some cases, there are private clubs that are having parties of one form or another on New Year's Eve where they will be serving alcoholic beverages. What are the parameters around the legality of these? What do they have to do to qualify to be able to do this?
Well, Dennis, a private club is, of course, supposed to be exactly what it means. They are private and open to the members and guests of members only, and not open to the general public. That's the reason that they are permitted to sell alcoholic beverages on Sunday to the members and their guests only. They must have membership cards. They cannot just walk up to the door and say, I want to join today and get salt because I can get in right at this moment. They make application with this particular club, and the law requires that there be a 7-day waiting period, and then this particular applicant be voted on by the membership before he's admitted to this particular club. But being a member and a guest of a member, they are permitted to sell legally on Sunday.
What will the Alabama Alcoholic Beverage Control Board and the enforcement and license inspectors be doing special this Sunday in anticipation of the New Year's Eve celebration?
Dennis, we of course won't be doing anything that we don't normally do. We work out of this division on Sundays, Saturday nights, Friday nights. We work when the majority of the people are out patronizing these licensed establishments. And it's, like I say, it's nothing unusual. We'll just be out as usual on Sunday to see that the licensed places are abiding by the state law.
The fine for persons convicted of selling, giving away, serving, buying, or drinking alcoholic beverages on Sunday in a public place is a fine from $10 to $100 and imprisonment in the county jail of up to 3 months. For the holder of the liquor license, it could mean the suspension or cancellation of their license. Dennis Latham, WSFA TV News.